Welcome to the Professional Dog Trainers Australia podcast, Dog Training Matters. Dive into effective training and behaviour modification techniques, share expert insights, debate hot topics, and discuss how to build strong, positive relationships with our canine companions. Whether you're a seasoned trainer or just starting out, join us as we champion methods that respect both dogs and their human partners. Let's embark on this journey together to elevate the world of dog training, because dog training matters.
Hi, and thanks for joining us today for the Professional Dog Trainers Australia podcast, Dog Training Matters. I'm joined today by my co-host, Steve Courtney, who is the PDTA president. So, g'day, Steve.
Hey, Trish. Hey, Kelly.
We are joined today by Kellie Elia, who is an animal management specialist, and Kellie consults with various local councils in Perth and WA. G'day, Kellie.
Hey, Trish.
So, Kellie, we're going to be talking about part 2 of the Dogs and the Law podcast, and today's subject is council-related legislation and bylaws, and I thought you would be the perfect person to speak to about this and ask you all the nitty-gritty questions out there. So would you mind just telling us a little bit about yourself, Kel?
Sure. Thanks for having me, Trish. So I'm a qualified animal behaviourist and dog trainer, and I run my own business in the Doghouse WA out in Perth, and I'm a consultant for local governments across Western Australia. So primarily I'm a subject matter expert at court for dog attack matters, prosecutions, dangerous dog declarations, and also reviewing legislation for councils for their local animal laws. And I'm also heavily contracted by dog owners who need to defend a dangerous dog declaration or need to defend a dog attack in court. So, yeah, essentially that is the work that I do, and I've been doing this work primarily for the last 20 years and the last 7 in WA.
So that's really interesting. So you're sort of working a bit of you sort of cross-reference, don't you? Like you consult for the council, but you're also on the animal owner's side. Is that correct?
Correct. Yes. So I'm on both sides of the coin.
Well, I don't think we have anything similar to that here. Well, here in Victoria, I know we don't. I don't think so anyway. But yeah, it's a really interesting concept that you do that. Is that something? Is that a council initiative, or is that a council role, or how does that come about?
So it actually started as a council role as an animal management specialist, where I was working primarily for an individual local government. And that was a very unique initiative by that local government to bring in a qualified dog trainer, a qualified animal behaviourist with high-level qualifications to review dog attacks and dangerous dog matters from a dog behaviour perspective and build education programs within the community for dog owners. And it then spawned out to me working with other local governments across Western Australia as they got wind of this initiative. And it then grew into me doing it myself as a consultant and in various formats. So building programs, acting as a representative in court, and yes, for both sides. So for the prosecuting local government or for the defendant as the dog owner.
That's really interesting. Do you know of anything like that, Steve, in New South Wales where you are?
No, not really. I do work with councils and AMOs and those sorts of things with dog owners, but generally, in many cases, either maybe the dog is referred to us by council, so the owner comes, or the owner comes to us and we try and liaise and maybe help, those sort of things. But I don't know if there's any, I suppose, interaction in that way. Not I know of anyway.
Yeah, I find that really interesting. So, Kellie, you did touch on the declarations that the councils give, and I know that here in Victoria, you've got your menacing declarations or your dangerous dog declarations. For those at home and for those that may not understand what they each mean, let's start with the dangerous dog declarations. How does that differ from state to state? So obviously these are dogs that have been involved in serious dog attacks of some sort. So is there a difference from state to state that you know of anyway?
Sure. So, yeah, it does definitely differ. So each state has their own state-abiding legislation. So that is different, or for some states similar, depending on what legislation they are using. And a dangerous dog declaration essentially means that your dog has formally been declared under that legislation and now has to abide by those restrictions under the law. So I think, to start with, one of the biggest differences that I have seen is in Victoria, where you are, once the dangerous dog declaration has been made, it's unable to be revoked at all. It is for life.
That's great.
In Western Australia, it can be revoked. So it can be reviewed after 12 months and it can be revoked. So that's probably one of the main differences that I would see. The rest of them vary amongst states with their wording, essentially, as to why the dog can be declared. And they also vary slightly with the restrictions. So again, in Victoria, they have very strict housing restrictions. In Western Australia, there's no enclosure as such for a dangerous dog. The enclosure is the backyard itself. So they vary slightly with the how and why the dog can be declared under the legislation, and then they vary slightly with the restrictions that apply to the dog. One of the other main things is, in Western Australia, dangerous dogs don't require desexing. I know in Victoria they do. So there are slight changes with things like that. But for the most part, the meaning is essentially the same, that your dog has been involved in what would be seen as a more serious incident, or has shown a tendency to repeat what is seen as aggressive behaviour, and the dog's now been declared formally. So quite a serious declaration, but there's also some variation in how it can be applied depending on the animal management officer that might investigate or make the declaration. And that's, quite a contentious issue too, particularly here in WA, that some animal management officers might make a declaration whereas others wouldn't. So, there's a lot of variance within the legislation as well. It's not a very succinct law, and it probably needs to be reviewed. The legislation in Western Australia is the Dog Act 1976. So, there's a lot of there's a lot of room for improvement in any of these legislations.
I suppose, as you said, there's lots of variations, and I think Victoria looks like to be the strictest one, because we do require, the dog to be in an escape-proof run. The dog's got to wear a muzzle, a collar, a dangerous dog collar. So there's a whole heap of stuff. And of course, it's got to be desexed and all that sort of thing. And yeah, it stays with them for life. And I see here, because just for everyone's reference too, there will be a list or a document that you'll be able to access on the PDTA members page that'll have all the variations from state to state with regards to dangerous dog and menacing dog declarations. So for those of you frantically writing out there, you don't need to do that. It'll be available to you in a document. But I'm just looking at the one here for the Companion Animals Act 1998 for New South Wales, Steve, and it says that the dog or it has attacked or killed a person or animal, and not including vermin such as rats and mice, without provocation. What does provocation mean? Like, what do they determine? Do you know what they determine? Or maybe, Kellie, you might know what that means?
Look, in my experience, if you consider that word provocation, it's sort of, in some way, shape or form, you could argue that no dog bites without provocation unless that dog has some sort of idiopathic aggression. So at the end of the day, the dog would consider, maybe eye contact or someone reaching out to pet them when the dog is not comfortable with that, provocation for them to take some sort of action to prevent that, so a type of avoidance-based aggression type of affair. But in speaking with councils in this sort of situation, generally in their own feelings, they're talking about what they call reasonable provocation. And that they might be things in the AMO where they would say, look, I think it's reasonable if you went up and kicked the dog and it bit you, but it wouldn't be reasonable if you accidentally stood on its toe. And another AMO might say, if you enter the dog's personal space and he doesn't like it, that's reasonable, and another might not. So that variance there doesn't give us, as Kellie said, a black and white line to be able to say that's not on, or okay, that's understandable. So this makes it a little bit sort of up to the officer, ranger, AMO at the time, and the person and the dog, and sometimes what breed it is, and the severity of the injury, and lots of other criteria.
Yeah, I have to agree with what Steve's saying. I think certainly from a court perspective, when you go to court and you are arguing provocation as a defence, what a judge or a member of the State Administrative Tribunal is looking for is an action. So is an action that is seen as provoking the dog. So another dog running up to a dog and attacking it, and that dog defending itself, causing more damage, may have come off okay, but the owner of that dog is arguing provocation. My dog was provoked. Someone coming onto your property, being aggressive towards you, that is seen as provocation. They're looking for an action. So provocation in court has to be something that is an action that is seen as provoking your dog. So it's not enough to just say, I was walking my dog and another dog eyeballed it in the wrong way and my dog, took issue. That's not going to be enough. It needs to be an action defined as something where there has been contact or attempt at contact. So there almost needs to be the same definition applied on the other end. So the definition of a dog being declared dangerous can be a rush, threatening to attack, baring teeth, snarling, anything that comes across as aggressive. Certainly in WA, the declaration can be made without the dog even making contact, without actually even biting. So in court, the same rules need to apply to prove provocation. You need to essentially prove that the other dog or person involved also was threatening to attack, and what actions were they doing? Was the dog snarling, showing teeth? Was a person kicking, punching? So you need to prove the same law on the other side.
So just on that too, Kellie, part of that would be some consideration to the other dog's intent. So in other words, if the other dog says, I'm going to go over and grab that dog by the back of the neck, your current dog said, oh, no, I wouldn't be comfortable with that, and shows aggression, someone would go, okay, there's some intent there. But then the same thing could be said where the dog came over and it didn't intend to grab the dog by the back of the neck, but it rushed over, stood over that dog without making any contact. That would be definitely the dog in question may consider that provocation and may defend it with some physical behaviour.
Yeah.
Of course, the law might say, well, he didn't make any contact or his intent wasn't there. And this is where it gets a little bit cloudy.
Yeah, really interesting point. Yeah.
This is the difference where, because we'll get into the menacing dog declarations, because I think in Victoria, if the dog rushed, barked at and things like that, but actually didn't make any contact, that's where the dog can then be declared menacing.
Correct.
And in Victoria, the dog actually has to cause a serious injury or an injury that requires medical intervention like stitches or what have you. So if the dog does that, then it could be declared dangerous. And that's, I think, the difference. Whereas with menacing dog, it's the rushing, it's the sort of, if the dog feels obviously is provoked, but if it's the rushing, even the unprovoked rushing, or the dog rushes up to someone, might bark or growl at them, but doesn't actually make contact or doesn't actually bite them, that's the difference there. So I just want to move on to menacing if we could, because the interesting part is the WA doesn't have a menacing dog declaration, whereas Victoria and New South Wales, and it looks like the rest of the states do to a degree, and ACT doesn't as well. I'm just looking at the notes here. So WA and ACT don't have the menacing dog declaration. In Victoria, the menacing dogs, that can be overturned after 12 months. So whilst the dangerous dog declaration stays with the dog for life, in the menacing dog, after 12 months, if the dog has been rehabilitated or what have you, the owners can apply to have that overturned. What's the differences there, and with regards to from what you know there, Kellie, with regards to menacing? And obviously without it in WA, it just comes under the dangerous dog, doesn't it?
Yeah, so there's no menacing dog law in WA. I think that the menacing dog law is what I would what I refer to as a softer step. So it's essentially a softer step in addressing a dog that's been involved in some sort of what is seen as unreasonable aggression or behaviour or a non-serious bite. So usually it's something like a rush where it's resulted in contact with teeth. They might have ripped clothing or something like that, but it's non-serious. So it's a softer step where the local government is saying, hey, we want to address this, we want to stop it. And you've now got 12 months to rectify and address that behaviour, and it can be assessed again in 12 months. My opinion on it really is that the only state that this is really effective is Victoria, because there's a distinct difference between the menacing and the dangerous dog law. So the menacing dog law can be revoked after 12 months, but if your dog is declared dangerous in Victoria, it's for life. It can't be revoked at all. In the other states, other than WA, where menacing doesn't exist, the menacing dog law and the dangerous dog declaration can be revoked after 12 months. So given that there's not a huge difference, there are differences with the restrictions that you need to abide to between both. But I think for states like New South Wales, and Steve might correct me if I'm wrong, but New South Wales, Queensland, the difference between the two, I just sort of think it's a little bit of overkill, because both declarations can be revoked, whereas in Victoria there's a very distinct difference between the two.
I agree with you to some degree. I suppose sometimes when a dog has done something like potentially bitten a person while they're at the park, if they declare the dog dangerous, it's going to be one application of the declaration. So they're going to say, you must build the dog enclosure, the dog must wear a muzzle, you have to have a sign on your property, and all the things. Menacing, they can just select seemingly parts of it and go, well, you know what, he's never got out of your house, so don't worry about the dog enclosure, just have a muzzle on him in public. They
Correct,
can do that.
yeah, it's a little bit more
They can give you just
pliable.
various parts, or they can give you all of the elements and say you have to have all, but it's still menacing.
Yeah.
And we also have a nuisance dog order here as well. So I guess they're just tiers, it appears to me, where they go along and say, well, there's not. I've seen dogs that have done things and be declared menacing, and I've seen dogs do less and become declared dangerous. Now, when we go along and say it's all to do with the AMO, to be honest, it's sometimes to do with the owners. So at the end of the day is that I'm trying to explain to people very often that this isn't necessarily a penalty. More of this is that the council is giving you mandatory restrictions to protect your dog from doing this to somebody again. So they don't trust you to manage your own dog. And this may be because the dog has got out a number of times, or you mishandle the dog, or whatever else it may be. So, they really need to understand that instead of letting you decide how to manage the dog, that's what's happened to date, the dog has done something and you didn't manage it correctly. Now they're going to council manage it to a degree, which could be dangerous, which is all of the restrictions, or it could be menacing, it could be anywhere from some to all.
It's a good point. It's an opportunity. It's an opportunity, and that's why I refer to it as a softer step. It's an opportunity for the dog owner to not have to go fully with the big restrictions of dangerous dog, and for them to rectify behaviour. I think the way Victoria do it is very good, and I agree with what you said earlier, Trish, that Victoria does seem to be the harshest. But, as an animal management specialist and having seen a lot of the really ugly side of what dogs can do in the community when things go wrong, I don't think it's a bad way that they are doing it. They've got some very strict measures in place, whereas WA are a lot different to that. So absence of laws, move to WA. It's a lot freer in that way, whereas Victoria have a lot more laws around dogs in general.
I wish they were stricter on crooks, same way they're strict on dogs. But anyway, so what we'll do, just for the listeners, as I mentioned earlier, there will be a document, and that'll have all of the different declarations per state for you guys, if you're interested in learning a little bit more about what your own state does. It'll be there. It is just a bite-sized information. It's not going right into all the bylaws and everything like that. It's just some bullet points, just so that people can understand the differences. So, yeah.
So a question for you is that, and a lot of people, this is their greatest fear, is, can you explain what council AMO's power to seize their dog and under what circumstances can they and will they do this?
Yeah, I think that word seize does put a lot of fear into a lot of dog owners, but it actually doesn't mean what people think it means. So in Western Australia, I'll talk to predominantly, but essentially animal management officers have the power to seize dogs for a variety of reasons. But what it really refers to is that they are taking that animal into possession until such time as it is claimed or released. And it has to be released most occasions unless the local government has received approval on a court order to hold the dog. So seizure really means I am holding your dog, I have possession of your dog. The local government is obliged to tell the owner where the dog is being held, the reason that they are holding the dog, and the time frame in which the owner has to collect the dog and what they need to do. So the word itself invokes a lot of fear in people, but it's not as harsh as what people may think. So in Western Australia, we can seize dogs if a police officer informs us to. So many times I've been called out to attend a property where police are at the property for one reason or another, and they have asked us to seize the dog. So this could be to no fault of the owner. So I've been to properties where the owner has had a heart attack and the ambulance is there, the dog is distressed, the dog is becoming a bit aggressive toward the people in the home, and they've called animal management officers out to seize the dog. And all that means is that we are taking it into our possession until such time as the owner's able to claim. We are able to seize a dog for wandering. So wandering dogs are seized by the local government, and we have to issue the owner notice in writing that we have seized their dog, where it's being held, why.
Can I just interrupt just quickly? Just something just popped into my head. So when you seize in WA, when you seize a dog, does the dog have to be contained in someone's property, or can you go and seize the dog that's at large somewhere? Because in Victoria,
no. So sorry, it's different in Victoria, I think, but in Western Australia, we can seize the dog from anywhere. The only place we're not allowed to enter is a dwelling, what's known as, so is the person's actual home. We're not allowed to enter inside their home. But if an officer is in pursuit of a dog for the purpose of seizing it, so, the harsher term of where we use seizure is that your dog's been involved in a dog attack or your dog is a dangerous dog, and we are seizing the dog because we have reason to believe that it's been involved in an incident. We can take the dog from your yard. We can take the dog off the street. We just can't enter inside the person's home.
That's really interesting, isn't it? Because I know in Victoria they generally, and someone can correct me if I'm wrong, but they've got to be contained on someone's property before the AMOs can actually go and seize the dog. They just won't, from what I know, they won't seize a dog that's at large. And again, maybe someone can correct me if I'm wrong, but that's my belief. Yeah, interesting.
I'll look into that and give you some notes, Trish. Yeah, but seizure is usually referring to when a dog is at large and the local government, the AMO, the ranger, picks it up off the street. Essentially, they are seizing that dog. They're taking it into the local government's possession. So this is where the term seize can have different meanings. If I'm knocking on someone's door to say I'm issuing a seizure notice for your dog or a seizure under warrant because your dog's been involved in a dog attack or something has occurred, that's a different kind of seizure to me picking up your wandering dog off the street and taking it into care.
It's impounding that dog, really.
Correct. Yes, impounding.
In WA, can you seize a dog for not being registered or microchipped?
You can, yes, yeah. So it is an offence for your dog not to be microchipped or registered. It's very unlikely that would occur, but I have seen that occur where a dog has gone unmicrochipped for a long period of time. The local government has given a lot of warning. Infringements have been issued, prosecutions have occurred, and nothing has changed, and they have issued a seizure on that dog. Sometimes animal management officers too, they will do things as a means to an end. So often dogs that are not microchipped can be dogs in poor situations that have been not well cared for, that can show some, unfavourable behaviour, and the owner is not someone that you can work with. So they may have other issues with the dog. So usually they would not seize just for that alone. The dog is likely to have also been involved in other incidents, and the local government is trying to address the issue with that dog. So it's usually part of a bigger picture.
Yeah, I find that, these things are probably often, or definitely years ago, seemed to be aimed at non-responsive owners who wouldn't keep their dog in, or wouldn't take any action to prevent the dog from chasing people down the street on a bike or whatever it may be. And more serious laws were involved. But I do find now a lot of genuine people get caught up in this net where, their dog manages to do something in a tricky situation, and they would do, they will take any action required. They didn't understand the dog was dangerous or would bite, or in that situation, it's not that they're knowingly walking around a sharp edge. It's that something happened that's never happened before. So,
is it true, Cal, because I'm just reading your notes here, that in WA, and WA must be a really easy state, because if the dog is declared dangerous, they can still keep the dog entire and breed from it. Is that true?
Correct. Yes.
Oh my goodness.
Yeah. Isn't that amazing?
It's blown me away completely.
Yeah. So I had a case recently where the dog had been involved in multiple dog attacks. The dog was declared dangerous after working with the owner, heavily working with the owner, providing free dog training, advice and management. The dog was eventually declared dangerous. He then bred the dog, and the dog had multiple pups. So we then had a situation where we had a dangerous dog with multiple pups, and that started the whole process again, where we had to get him to move these pups on, because you can only have a maximum of 2 dogs on the property. And, this is where the cycle continues. And, this is probably a whole other podcast of the reason why this dog was dangerous, the way in which he bred this dog, and the mix of breeds, which in the hands of the owner that the dog was in, I can already look down the future and tell you what's going to happen in the next couple of years. But unfortunately, that is the case. They are able to breed. There's no law against that.
That's phenomenal stuff.
Yeah.
Wow.
Yeah.
Wow.
How do you help dog owners that their dog has been involved in an incident and you're trying to help them avoid a declaration? What are your recommendations?
Yeah, thank you for asking this, because this is probably what I see as the most valuable and enjoyable part of what I do. So usually it's about explaining to the dog owner why this has occurred. And it goes back to what you said, that the majority of these people are, they're good people, they're good dog owners. They just don't understand dog behaviour, and nor should they. Just having a dog doesn't make them a dog behaviourist. Just like, I drive a car, but I'm not a mechanic. So it's about explaining to these people why this occurred. And I'll give you an example. Recently I've worked with someone who has a border collie. The border collie has twice attacked a child riding a bike, and very minor, so it's nipping, but the dog's never done anything else. So, I'm heavily trying to explain to the dog owner, this is the breed of dog that you have, and do you notice that this dog hasn't just ran up to a child in the park and attacked a child? This dog has only done this when there's been a bike involved, when there's movement involved. So you're trying to explain to the dog owner why this has occurred, because the first thing for me is that a lot of these people look at their dog and they think, oh, my dog's a bad dog. Now I'm not feeling confident with my dog. I don't trust my dog. And in some of these cases, the dog, shouldn't be trusted, but those cases are very rare. And I've been doing this a long time, and majority of why dogs attack, it's very predictable. there's a reason for it, and explaining that to the owner gives them a light bulb moment. So they're really able to say, hey, I can understand why this happened now. How can I stop this from happening again? And then we can get into the work of, well, this is how you stop it from happening again. And then usually after that, it doesn't occur again. And the big work that I do is when dogs have been involved in a dog attack. So those attacks are graded in levels of severity. So I would usually go out if there's been contact that's resulted in minor to moderate sort of injury. I would go out and intervene at that stage. And the majority of those owners that I'm working with, their dogs do not reoffend. And that is the real important work that local governments should be doing, because that is how you prevent dog attacks. There's a very small number of those dogs that offend again, and those are the ones that the owners are not on board. The owners are not switched on. The owners don't care. The owners you can't work with. And that's why it happens again, and then usually leads to a dangerous dog declaration. But for the majority, if you can get to them after the first incident and the owners are switched on, then you're able to prevent it from occurring again.
In Victoria, and we spoke about this on the first podcast that we did with Mock Fortemeyer, who's the dog lawyer here in Melbourne. In some cases, if a dog has been involved in a say a serious incident, and the council is looking to declare that dog dangerous or even a destruction order or what have you, sometimes if the owners engage in the services of a dog trainer and say, rightio, well, we're starting to take the dog to training, we're doing this, we're doing that, we're working with the dog trainer, in some cases that can look favourable for the owner in a court, like if it does go if it goes to a magistrate's court or a court. Is that the same in WA and also New South Wales, Steve, where if that happens and then they engage the services of a dog trainer and then it goes to court or it goes even into the council and they say, well, we are now taking this dog to training, in Victoria it can be seen as favourable and it can reduce the declaration maybe down to a menacing or what have you. So do you find that's the same in WA and New South Wales and other states, I suppose?
Definitely
Yes.
it depends on the council here too. So there are plenty of councils that take this as, yes, what we actually are really interested in is preventing any type of repeat event. And if they would come along, and some would recommend us, some people would say, I found these guys and I'm going to work with them, and we can furnish council with reports and agree or undertake to, every time the person turns up for training, send a report to council with our opinion on risk and safety and all those sort of things to make sure the people are there. And of course, if they don't turn up, we have to let them know that too. And very often this can be a negotiation between a very good proactive council that's trying to say, look, I'm trying to resolve the problem rather than just throw a bunch of restrictions at the dog. And we have, we're lucky enough in New South Wales that a lot of AMOs, that's the path they're willing to take.
Yeah, I think that's the key, Steve, is a very good proactive council. That is the path that they should be taking. Certainly in WA, if your dog's been involved in an attack and you said you wanted to appeal that, you received an infringement, you wanted to appeal it, it likely wouldn't change the outcome if you said that you were working with a trainer. But certainly if you went to court and you were prosecuted over that dog attack, it would be taken into consideration. But for a dangerous dog declaration, most people that take that to court to either have it overturned or to go at the 12-month mark for it to be revoked, most of those people have seriously engaged with a trainer and they have a proven track history of evidence to show what they've done with their dog and why they think that results in that declaration not being applicable any longer. And it is seen very favourably, but it depends again. I mean, everything is so subjective to who you get, who who your AMO is as to who your judge is and how they see your dog's behaviour. And a lot of it can depend as well on what's happening in the state at the time. So I've had a case recently which the breed of dog had been heavily in the news, and when this owner, who was a very, very switched on, very dedicated, had done all the work, took her case to the State Administrative Tribunal, I could tell straight away that the presiding member was not interested because of the breed of the dog. That breed of dog had been heavily in the news. So there's many factors that can come into play, but certainly having had a track history of showing that you're willing to change the dog's behaviour, that you're putting money towards it, you're committing finance and time into changing it, goes a very long way.
I think it's a pretty important thing to be aware of is that if we just declare a dog, say, menacing or in New South Wales dangerous, and then in 12 months the person asks to have that revoked and they're successful, there's no indication that or I suppose mandate that they've actually trained the dog or made the dog any safer. And of course it won't be any better just simply being restricted, versus a more proactive approach might be accepting that the dog has a behaviour issue. And what we need to be able to do is we need to work on that and get this dog to a point where it doesn't provide the same level of risk to other people. So that's where I often say to some AMOs, it would be better if these people spent the next 12 months working on this rather than simply just say your penalty is restricting the dog, in a dog enclosure, putting a muzzle on and all the rest of it. Because if somehow that dog gets that muzzle off or gets out of that run or is not handled properly, that aggressive behaviour is still current in the dog. As we start working on it, we'll either reduce that behaviour, change that behaviour, maybe even eliminate that behaviour, but at least we'll be educating the dog owner of how I guess, risky the dog is through multiple applications of training.
And then the owner
have
to do that too. The owner's going to want to have to do that and pay for it as well. That's the other thing too. So some owners are, they're willing to invest the money and the time, and then you get others that are just do it the bare minimum of what's required. They don't really care, which is the sad part really at the end of the day, because the dog pays that one.
The other thing to consider is that the person that revokes the declaration, their individual name goes on that document. So for myself, in the last 7 years, I have revoked one dangerous dog declaration, and that dog, the declaration was made prior to my time at this particular local government, obviously not by myself. I didn't agree with the declaration being made in the first place. And obviously, I'm looking at things through a different lens from a dog behaviour perspective. The dog was a rescue. It had been adopted, and on the very first day it went home with this family. They took it to the park off leash, and the worst happened. There was a lot at play in what happened that day when the dog was declared, but these owners did a lot of work. They worked with a reputable trainer. They had a lot of history and evidence of that. But then I myself had to assess the dog. So for me, assessing the dog and then writing my own recommendation and signing off on that, I'm putting my name as an authorised officer on that document to say, I, Kellie Elia, revoke this, I support this. And I have to have that on my conscience that if that dog then goes and does something, I was the one that unmuzzled that dog. I was the one that made that call. So I think that there is some risk aversion on behalf of authorised officers to revoke declarations because they don't want to be responsible for removing those restrictions and then the dog's involved in another incident. So there's a lot of that at play as well. But I think that is why local governments really need qualified dog trainers, qualified professionals to make these assessments, because an animal management officer is not a dog trainer, is not a dog behaviourist, has very limited training in dog behaviour. They're trained in laws, so they're trained in regulatory laws. They're not trained in animal behaviour. So they're looking at things from a very different lens as well. And That is why it's really good to employ good professionals whenever you're looking at having these things turned around so that the right assessments can be made.
I think really, really important is something that we push a hell of a lot is that when people are getting dogs, especially as a puppy or a rescue or whatever else it may be, is to try and start training and get this dog to understand socialisation values and be responsive, learn impulse control and so on before these problems develop. And, raise and educate your dog properly. And if this sort of happens, the chance of you getting caught up in these type of declarations and laws is extremely minimal. And then you won't have to be concerned about, can I get rid of this? Can I stop this or do whatever it may be? It'll just never come to your home. But most people are more reactive and require training on demand where they go, oh, something's happened. I need you to do something now. And in reality, the truth of the answer is you actually needed us to do something 3 years ago, and then we wouldn't be here right now.
Yes, very true. I couldn't agree more. And this is where the educational programs for dog owners are so important and should be given a lot more of the spotlight by local governments, in my opinion, because there's just so many dog owners that don't have access to quality dog training for one reason or another. And for most Australian families these days, committing funds to dog training is probably not high on their priority list, or they do it, as you say, when something has gone wrong. But educational programs through your local government upon registration or whatever it may be are so important because prevention is always going to be the biggest thing. And there's just so much that a lot of people don't know, so many simple things that lead to dog attacks. The most common of which is my dog ran out my front door and bit the postman. That accounts for a large percentage of dog attacks that we see, and so well addressed by crate training your dog or having your dog have threshold training or just even putting your dog outside. I mean, these things are management, and management can always fail, but just the basic things that people don't think about that lead to the most common dog attacks that we see. Recall is another one. Dogs off leash at parks with no recall, and my dog has to be everyone's friend. We all know this one. Or my dog is friendly. This is the other most common cause of the dog attacks that we see. Are dogs rushing up to other dogs, either on lead or off, in dog parks, at dog beaches, all of these things, and the owners just not knowing, genuinely not knowing and not understanding that this is just not conducive to good dog behaviour. This is just not how dogs are meant to be interacting favourably. It doesn't have a positive outcome most of the time, and it's not a matter of if something's going to happen, it's a matter of when it will happen. And we get so many dog attacks from those types of environments. If people knew and had training on these types of things, it would be so prevented.
Thanks for that, Kel. That was very, very insightful. I'm just curious, in Victoria, obviously, sometimes if there's a dog attack and the people go to seek legal advice, sometimes they'll go and they'll engage the services of a behaviour expert or a dog trainer. How does that, a behaviour assessment from a dog trainer or a behaviour expert help the dog's cause? And does it happen very often that you see in WA? I know for myself and also for Boyd, we regularly do behaviour assessments for, various legal representatives who are helping out in a case, and the behaviour assessments can help greatly. How do you see that helps or influences what maybe the courts say or even what the councils may say?
Yeah, I think it can be very powerful, and I've certainly seen a lot of them that can be, and I do them myself. I think it depends on who is used and how good they are in their profession. But in WA particularly, I think they really need to be well known by the courts. Otherwise, if it's a name that they haven't heard before, they're not as willing to give your testimony as much of a consideration as if it's somebody that they know. The law is very black and white in court, and on most occasions, there's not a lot of speculation by the judge or presiding member as to the reason for the dog's behaviour. And the judge is really looking at what happened on that occasion and whether it meets the requirements for the declaration or the penalty. So to a judge, it's very 1 + 1 = 2. What happened? Does it meet the requirements under the law? Yes or no? Whilst the dog behaviour or the dog trainer's statements can be very powerful, they don't usually often take them into consideration to change an outcome when a prosecution is being undertaken. So a prosecution might be that your dog's been involved in an attack, and instead of receiving an infringement, the local government is taking you to court. So an infringement in WA for a dog attack is $400. But if it was, a higher level attack, or the local government felt it was something that they wanted to prosecute or make an example of, they can take it to court and seek higher penalties under the maximum allowed under the Dog Act 1976. So in that case, they may not take those statements under consideration as much, but certainly what we were saying before about dangerous dog declarations, they would be considered, particularly if you were wanting it revoked and you'd done 12 months worth of work with someone, and then that person had written an expert, witness report on your behalf. That would be very powerful.
That's really interesting. I've got a little story, if that's okay. I've got many years ago, I was called by some owners of a cattle dog. The dog had been declared menacing because it had rushed and chased a cat, and it rushed and chased a cat on the cat's property. So the owner was going next door to feed the neighbour's cat while they were away on holidays, and brought the dog with him. And of course, the dog rushed and chased the cat. And I think he caught the cat. He didn't quite kill the cat, but I think he injured it enough. They declared the dog as menacing, and it was about 12 months later, and they contacted me, and they wanted to obviously have the menacing declaration reversed. And the funny thing was, I went to the property. They lived there was a rural property, so they had their own acreage. And I said, look, I'm going to have to see what the dog is like around cats. And I said, I'm going to have to sort of maybe bring a cat in a crate or something like that. And they said, oh, no, you can't do that. And I said, oh, well, how else am I going to see whether you've done work with this dog and you've rehabilitated it and it's not chasing cats anymore? And they said, oh, no, you can't do that. I said, well, look, unfortunately, I can't just write a recommendation to overturn the declaration because you told me that the dog's okay, but you won't let me test it. Anyway, funnily enough, the female owner turns around. She said, we've actually trained the dog to chase feral cats off the property. And I just thought to myself,
wow.
Oh, look, I can't help you. I'm sorry. And they were really upset with me because I couldn't overturn them. I couldn't give them a testimony. Even the council, one of the council AMOs called me and said, well, what's the go? And I told him, I said, look, they wouldn't allow me to bring in a cat to do the test on a cat because I said the dog is being trained to chase feral cats off the property. So I said, I'm sorry, but I can't help you.
You've raised an interesting point though, because when you make these assessments, it's really hard to assess, particularly a dog that's been declared dangerous and they're wanting it assessed to revoke. How do you take that dangerous dog out into the community and test it in a real life situation? And this is where it becomes really difficult. I had a case recently that dogs were declared dangerous. Long story short, the owner went right through the appeals process and eventually hired a well-known behaviourist in Perth. And the whole context of that person's assessment was done in her office. So he took the dogs to her office. He parked in the car park out the front. He walked the dogs inside her office. She consulted with him. She decided that they weren't dangerous dogs, and she came to court to present that. So you can only imagine my rebuttal to that dog behaviour is very contextual. These dogs had been declared based on 2 separate incidents, very high level, one resulting in the death of another dog. So these dogs were not aggressive to people at all. It was related to dog aggression. But how can you assess them? There were no other dogs present during your assessment, and I directly asked this person on what premise they were basing this, and they said, well, I observed the dogs in the car park and I observed them walking into my office and I spent an hour with them. That's not an assessment, and that by no means proves that the dogs are no longer a danger to other dogs. So,
very frustrating.
Yeah, it's very frustrating.
So let's get back to the dogs at large, because we had an incident here in Melbourne, it was probably a few months ago now, where there were a couple of dogs that escaped a property here in Sunbury, Kelly, because you used to be a Sunbury girl, didn't you, many years ago?
I was, yeah.
Yep.
Yes,
so
yeah.
it was actually probably a few blocks for me, and the incident occurred. There were two or three dogs, all sort of rescue dogs, that escaped a property, and the first time they escaped a property, I think they attacked an elderly lady that was walking down. I think she had a walker, and so they attacked her, threw her to the ground. They caused some injuries to her legs. The dogs, I think, were seized and then went back to the owner for some reason. I hope I get the story right. But then the second time the dogs escaped, they attacked a lady who was pushing her pram with her baby in the pram, and the dogs rushed her, and she tipped the pram upside down to protect her baby while these dogs went to town on her legs. Now, eventually they were pulled off. The owner came out, got the dogs back inside. But this is an incident now where twice the same dogs were at large. And I think from what I know, the dogs were seized and destroyed, which should have probably happened the first time. But anyway, so what's your takes? Like, what are the general occurrences, and maybe some stories that you can give us of where you've had to go and retrieve a dog that's been at large, and what are the instances there that you can share with us?
Yeah, so wandering dogs are the most common complaints that local governments receive in their animal management department. It is a huge drain on resources in the majority of cases, because a lot of the times you'll receive the report that the dog is wandering and it needs to be investigated, but by the time you get there, the dog's gone, or the dog's returned to the property, or you can't find the dog. So it's quite frustrating. But most of the time we find that dogs have escaped through a door or a gate being left open. And I do find that majority of these dogs that then go off and wander are usually quite confident dogs, because they're happy to go and explore and go on an adventure. Off they go. They often return home if they're not caught. And we do get a lot of these. So a lot of dogs that are repeat offenders as well, that often with kids at home. There is one dog that I've dealt with, impounded 12 times, the same dog. The children will often leave the front door open, they play in the front yard, and the dog goes off and goes on a wander. Yeah. Very frustrating, but there are a lot of dogs that get out of the house but they don't leave the property, and these are the ones that we find most troubling, because most of these dogs are remaining on the property because they're displaying territorial aggression. So they're in the front yard, someone's walking past down the footpath, and the dog will rush them in a very aggressive manner, but doesn't often make contact. If the person moves on, the dog will back off. But these are really tough ones, because essentially by law, as long as the dog doesn't cross the property boundary, the dog is actually on the property still. But, it's causing a big issue to people in the community. We do have cases where dogs have escaped through broken fencing. We have a lot of these cases where these dogs have come from housing authority homes. So majority of dogs that escape properties through broken fencing or a door left open or something, you can address it with the owner. They can repair the fencing and there's not an issue again. These repeat offenders are often from housing authority homes, and the issue does not get addressed, even through working with Department of Communities. It doesn't get addressed, and the dogs are not well socialised. I did prosecute a case recently, 2 dogs that escaped the property and viciously attacked a person jogging on the street at 5 o'clock in the morning. This person nearly lost their life and was very lucky to escape. There was multiple people that witnessed the attack from their own homes but were too scared to come and give assistance. They escaped through broken fencing. The dogs were repeat offenders, and this is where it gets really tough because local governments can be very risk adverse to applying penalties to owners and keep returning dogs back to the property. And then that dog can get out and cause some serious damage. This case was particularly bad, and this person will have the scars of this mentally and physically for the rest of their life. That did result in both dogs being destroyed.
Yep.
And it's probably one of the cases that was the right call. Majority of times I don't agree with the dog being destroyed because it's usually preventable or the dog has made an error where the dog didn't know better. These dogs were what I would call truly aggressive, and it's a hard call to make. It's one I don't make very often, very rarely, but was the correct call at that time. But wandering dogs are a huge risk to the community, and not just to people, but to other animals, to themselves. That's the thing. We get a lot of dogs that get hit by cars, but a lot of people, they just don't put the management in place. They're very lax. I mean, I know after I've taken my own dog out and I come back into my yard, I check my gate 10 times because probably with the work I do, it's in my mind. But a lot of people just don't have that level of security and making sure that their dog is secure. Mm. And if your dog gets out, it can cause a lot of trouble.
Now, what also happens, so we know that obviously, that the effects on the dogs and what happens with the dogs in these cases, whether they are declared, whether it's menacing, depending on the state that you're in, or dangerous or destruction. What happens with the owners? Like, what happens to these dog owners? Are they penalised monetary-wise? Do they sort of receive, never to own a dog again, or all those sorts of things? What penalties do the owners get if they've been involved? Let's just say in something fairly serious with their dogs.
Yeah, so it's a good question because the owners, apart from a fine, or it can be more serious. So local governments will tend to work in stages where they will issue a caution for something that is more lower level. And a caution does not have any monetary value. It's a formal, it's on record, hey, you've been cautioned. So if there's a second incident, it would usually then escalate to an infringement. If it's more serious, the local government can decide to go to prosecution, and this is where they take it to court and they attempt to prosecute the owner under the full extent of the abiding legislation. So in WA, it could be a maximum of $10,000 for a dog attack under the Dog Act. So they could be trying to prosecute the owner for that amount. But it doesn't stop them from owning another dog. So this is where there's no crossover of legislation. So the only legislation that can prevent someone from having another dog again is an Animal Welfare Act. Mm. So that is in WA, that's administered by the RSPCA. The Animal Welfare Act does not correlate with the Dog Act. Sometimes prosecutions overlap because there may be a Dog Act infringement that they've done something against the Dog Act as well as the Animal Welfare Act. But someone in my role or an animal management officer cannot apply that type of penalty to a dog owner. So, the dog attacks that I've seen, so the one that I was just talking about with these 2 dogs, and I will name the breed in this instance. So one of the dogs was a Tibetan Mastiff.
Oh, yeah.
And the other was an American Bulldog. Mm. I mean, a Tibetan Mastiff, is a very particular type of dog, and this dog owner had done no work with the dog at all since birth since owning the dog. And the injury that is able to be inflicted by a dog of that breed is massive. So this gentleman that was running, the injuries that were sustained by him, he will need to have multiple operations still and ongoing therapy for the rest of his life. And the owner of these dogs was very negligent. So very, very, very negligent. The dogs had been involved in things before. The owner knew that the dogs were aggressive. Even when I went to seize the dogs, said to me, oh, they're very aggressive. You know, the dogs, they'll kill you. They'll try to kill you. They're very aggressive.
Wow.
But had done nothing about it. So that in itself was extreme negligence. But the owner, after going to prosecution, the owner was fined a total of just under $3,000.
Wow, that's pretty petty, isn't it?
So that's very small when you think of the trauma that this person went through, the medical bills that he has had to pay, time off work, that it's cost him a lot financially. But the sad thing and the really tough thing for me is that this person can go out and get another dog, you know, can go out and get another Tibetan Mastiff, and if that's their breed of choice, and not do any training with it or any socialisation with it, and there's nothing that I can do about that. There's no preventative action that I can take or that the local government can take with regard to that.
That's interesting. It's been a wonderful chat with you, Kellie. You really know your stuff, and that's really enlightening to know. And you know also the laws of other states, and that's been very, very informative. For those of you that have noticed Steve's departure, he did have to leave early. Unfortunately, he had a prior engagement. So couldn't stay the distance of the podcast, unfortunately, but that's all good. So, Kellie, I suppose if there's any questions, if people have any questions for you with regards to, you know, the laws in WA or anything else, how can they reach you? What's the best way that people can reach you?
Sure. So I do have a website, which is www.inthedoghouse.wa.com, or they can email me at K9Kellie, which is KELLIE @outlook.com.
Lovely. And we can put all those details in the show notes for anyone that might have a question for Kellie. You might think something that wasn't covered and you want to have covered. For the listeners out there, there will be some additional information coming your way obviously in a Word format or a PDF format. We'll post that to the members page. There are, you know, dog bite statistics and researches and papers and stuff for you guys to read if you're interested. If you would like to ask us a question on anything dog related or dog, you know, obviously dogs and the law related, you are most welcome to do that via our email, which is info@dogtrainersaustralia.org. If you are listening to this podcast and you're wondering who are the PDTA, we are the Professional Dog Trainers Australia, and you can find our website, dogtrainersaustralia.org, with all the information there. We do represent all dog trainers from all walks in Australia. Kellie, thank you so much for joining us today. It's been an absolute pleasure. Can I tell the people where you're speaking from? Am I allowed to?
Sure. Yeah, of course.
Kellie's in Bali, of all places. Like, she's such a lucky girl. and you wouldn't know because the internet seems to be really good. So, yeah, you're coming across nice and clear. But thank you for taking your time out from your holiday and your breakaway to spend some time talking about dogs and the law. And as you know, guys, this is part 2 of the Dogs and the Law series. We do have part 3 coming at some point, so do keep an eye out, an ear out, I should say. And if you haven't listened to part 1 of the podcast, you can find that where you get your podcasts from, and that is part 1, where we speak with Michael Fortmeyer, dog lawyer. Thanks, Kellie.
Thanks so much, Trish. Thank you for having me.
You have a wonderful holiday, and thank you everyone for joining us, and we'll see you or hear you at the next one.